I don't know what I'm doing. Today's one of those days I'm not prepared. I'm not prepared today. I was not prepared for this. I was not ready. Um, I'm here. This is crazy. What are we doing? Um, let's just roll an intro because I'm having a what the fuck. Here we go.
Rub around the model room welcomes all. Thanks for stopping by, answering the call. Ups and downs are normal for some of us. Many days I beg to get off this life bus. Neon lights flicker, my shadow on the wall. Dreams on the ceiling, we run and then we fall. Sharing stories over paper cups. Wheels keep turning but never enough. Life's a ride on a rickety old track, holding on tight, never looking back. In the rubber and liner room we confide, laugh, cry, love in this crazy ride. Dusty postcards from the edge of nowhere, heartbeats echo in the electric air. We dance on tables without to wait, cry in the rubber and liner room, we're all high.
Well, hello, 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 hello. What a wild, wild trial this turned into. You know, I when I first started this, I can remember reading that this was going to be unprecedented trial because, here we are, we're charging an assistant principal for the care of these children and uh, this has been interesting, and I am very glad I streamed it because it was very enlightening. So what we're gonna do is we're gonna watch today's proceedings, and we're gonna see some after interviews. There's a couple of them out there, not a lot yet, but there's a couple. So it has been interesting. The judge has dismissed. Yes, dismissed the case. So I, you know, I went in thinking, maybe I shouldn't be so judgmental. We should just step back and listen to the facts and not just run and judge. And look where we are. So I'm going to hit play. We're going to watch this out for a little bit. And yeah, look. You're like, "What? What? Say what? What the fuck happened?" Hey, K Swan. Yes, absolutely, Teresa. This went totally off the rails today. Didn't expect it. Oh, show comments on stage. Okay, sorry. Okay, so I'm gonna hit play. We're gonna let it do its thing. Hang on, let's get up here to where they actually come into court. And they're thinking they're coming in here for just a regular court day. And y'all see all that brass is polished. They all took their bras off and polished that brass. You know that's what happened.
Okay, just in case. Okay. Court is now in session. Honorable Judge Robinson
All right,
of
I'm
the
gonna be
Circuit Court
quiet.
now presiding. Ladies and gentlemen, as always, there'll be no coffee while her honor is on the bench. You may be seated.
Good morning, everyone. Are we ready to call the case of Commonwealth versus Parker?
We are.
Right,
And,
K-Swan?
to the meeting.
Okay, y'all. We listen and we don't judge. Okay, but I judge. I judge. I judge the judge for making the boldest fucking choice of lipstick today. You go, mama. You go. I come in here, I barely put a little bit of eyeshadow on, slap some lipstick on, but mama, let me go, Lola. We're not doing this. This is a short stream today. I'm not playing with you. The bold choice of lip color. Y'all, I really thought about pulling something out and going wild on y'all. You know what? I'm gonna turn my camera off. We're gonna let her talk, and I'm gonna surprise y'all.
Your personnel, the buttons that we have to press to turn on the audio are all in place? Okay, thank you. All right, so we're calling the case of Commonwealth versus Parker. For the record, let it reflect the Commonwealth attorney is present, Mr. Jenkins, with Ms. May. Good morning to you both.
Good morning.
The defense is present, Mr. Rogers and Mr. T. Good morning to you both.
Good morning.
The defendant is present, Ms. Parker. Good morning to you both. We arrested yesterday. Is there anything you need to address this morning?
Yes, Your Honor, I have two matters.
Okay, yes, sir.
The first is that the court yesterday, as I understood it, we agreed to admit the full and unredacted interview between Dr. Parrish and Dr. Parker. I needed time to just place that on a USB drive. I have done that. It's on Madam Clerk's counter there. I understood at the time that the court had admitted it, and I just needed to provide it. But if the court had not admitted it at that time, I am moving to reopen and admit it as Commonwealth 6.
Any objections?
Not any objections to reopening for the purpose of admitting that.
That's it.
Okay, so friends, Commonwealth is reopened, and we will admit it. Does Madam Clerk have it now?
Yes, it's
Okay.
right there.
All right, and this would be 6, Madam Clerk? Yes, ma'am. Okay, so admitted, and again, this is just the full video of what's already a redacted version in evidence. Okay, and now that that's done, do you rest again, Mr. Jenkins?
Yes, we rest the reopened case, yes.
Okay, and the second matter?
The second matter, Judge, is just as a preliminary matter, I understand that the defense, pursuant to their own subpoenas, intends to call as their witness several witnesses that have already testified.
We're gonna make bold choices today. We've done pink. I don't do pink. I'm too pale for pink, but it's okay. We're gonna do bold choices today. And that choke collar this judge got on today, she rocking that shit. She is rocking that shit. So these people come in and they're already talking about things and witnesses and all that, have no clue. No clue. All right.
Including Ms. Zwerner, Ms. Kovac, Ms. Parrish, Ms. West, perhaps others. And I just want, as a preliminary matter, to point out Jones v. Commonwealth 2023 VA Act, Lexus 294, decided May 16th of 2023, which holds that it is not proper for the defense to do any impeachment when it calls its own witnesses. And so I am asking the court to instruct the defense not to do any impeachment and not to recross on matters that they already had a full opportunity to cross on. But I certainly would not object to them eliciting new evidence in their client's favor from those witnesses. But in terms of recrossing the witnesses they've already crossed, that would not be proper. They're here pursuant to the defense subpoena. So I wanted to raise that issue.
Yes, sir, thank you. Response?
Yes, sir. We would be asking, in the event of calling these witnesses, that they be, that we be able to examine them as hostile witnesses.
Examine them as hostile witness. I mean, see, look, they come into court. They are fixing to fight this shit out, okay?
And so ultimately, we will cross that bridge when we get to it. You all are entitled to call whatever witnesses you wish, and if they meet the qualifications to be declared hostile or adverse and be treated accordingly by impeaching and or leading questions, then if they meet that statutory criteria, then that'll be allowed. So Mr. Jenkins, I understand your objection now, and it'll be ongoing. And when we get there, we will address it. But again, if they meet the criteria for being a hostile witness, the court will allow them to be treated as such.
I understand. Thank you.
All right, thank you. Okay, so with the Commonwealth resting, the defense asked to prepare, time to prepare their motions to strike, and we'll start with them this morning. Are we ready for that? Okay, I'm ready. Please proceed.
Your Honor, the Commonwealth has filed 8 indictments for felony abuse and neglect of children. I'm going to sort of assume that the Commonwealth is proceeding under the fact
that there were at least 8 children that were abused and neglected on January 6th. Your Honor, if that's the case, I would say the Commonwealth hasn't established that there were 8 children present in the classroom on that day when this incident occurred. The Commonwealth definitely hasn't established 8 separate incidents. So we have one incident where I guess potentially the Commonwealth believes that there were 8 children present. But the Commonwealth did not present the names of 8 individual children that were in class that day. They presented no roster or role that's confirmed by any employee that was on staff that day. And more importantly, the Commonwealth is required, I'll just read the jury instructions. In this charge, the crime of child abuse or neglect, Commonwealth must prove beyond reasonable doubt due to the following elements of evidence. And I know at this point there is.
I can tell you here in the state of Texas, in these smaller school districts, we were only allowed 20 children per class. So, it may be different all over. This is a small town from what I'm assuming, everything I've read so far.
Like understandable to the defendant was a parent, guardian, or other person responsible for the care of whoever these children are, these unnamed children, and that these unnamed children, this unnamed child or children are awarded.
And not to totally derail, but where's Miss Maria? Because she's our resident teacher and she would know a lot more. Maria, if you're on replay, mwah, thank you, miss you. You're in Metropolitan 30 to 40. Yeah, see, it's different all over. Now, if you go into Houston in the city, HISD, there's 30 to 40 kids per class. Now, out here in the country in Fort Bend, things may have changed, but back in the day, it was only 20. Well, good afternoon, Southern Cats. Glad you're here. By the way, we're rocking hot pink lipstick today to make the judge feel comfortable with her beautiful choice of lipstick. So, and we have not a mistrial, but a dismiss.
Under the age of 18, there was no testimony that any individual child that was present in the classroom by name was under the age of 18. Also, the Commonwealth has to prove that the defendant's willful act or omission in care of whoever these unnamed children are was so gross, wanton, and culpable to show a reckless disregard for human life. Jury instruction that discusses the definition of willful says, a willful act is one done with a bad purpose or without justifiable excuse or without ground for believing it is lawful. A willful act is intentional or knowing or voluntary as distinguished from accidental. The terms bad purpose or without justifiable excuse require knowledge that particular conduct would likely result in injury or illegality. Your Honor, in my own words, the Commonwealth has to establish that Dr. Parker knew, and her response was, so what? I know that there's a weapon and that there's a likelihood that children will be harmed by that weapon or firearm, and I don't care. Let whatever happen is going to happen. There was no evidence that was Dr. Parker's response to anything that happened on that day. She was brought limited information, and she responded to the information that she had. I asserted at the very beginning of this, if we look at the behavior of everyone that had contact with JT on that day, they did not believe that there was a firearm. They did not believe that there was a weapon. There was testimony from Zwerner. She was the person that had the most direct contact than anyone on that day. her behavior did not indicate that she knew that there was a weapon. She left JT in the classroom. She left other children in the classroom. Then we go to Ms. Kovac. Again, she sat with him, had her eyes on him, watched his behavior. She said it was weird, but her actions in no way indicated that she believed that there was a firearm in possession of JT. And then we consider what Mrs. West testified. She said there was,
not only lack of evidence, the fact of all these finger pointings of this person could have done that person could have done this. Of course we go in, and you immediately start judging because of things you hear and everything. And then that's when I took that moment and I was like, wait, let's take a step back. Okay. I'm going to try to go in here and not be judgmental. And it's really hard. It's really hard, you know, when you're on my end, because I automatically, I see things and I read things and I'm like, ooh, 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 ooh. But I'm stepping back. And this trial, I actually stepped back and I was like, first I'm like, ooh, and then after hearing these other people talk, I'm like, you know, mm, maybe she's not so, at fault. Yeah, she had things she should have done, things were done wrong, but I think a lot of people did things wrong on this day. There were so many other things that could have been done and didn't get done. So, and the musical telephones of this person told this person, and there was a lot. So I'm shocked that it went this way so fast, but we're going to let the judge explain it. I'll be quiet.
concerns. She actually observed JT on the playground with the other children. Based on her observations, she was satisfied that there was no weapon. And she only became concerned again when there was a report almost contemporaneously with the shooting that there in fact was a weapon. And then we consider the testimony of Mr. Rawls. He had a lot of contact with JT leading up to this event. On the day of the event, concerns were brought to him. He investigated, put his eyes on JT, was satisfied that JT.
She hasn't said it yet, but it's been dismissed, Cindy. It's coming.
Attended harm to
We're going to watch a couple reviews.
Based on the information that Dr. Parker had, she made decisions in hindsight. Those decisions actually were determined not to be the correct decisions. But that wasn't her decision wasn't an act of neglect. There was no bad purpose, obviously. She didn't intend any harm to the students without justifiable excuse. Your Honor, based on the information she had, she took actions that she believed were appropriate based on circumstances. And so there was no bad purpose. There's really no excuse that we're trying to say other than she did not believe that there was a weapon, so that explains her conduct on that day. So there was no information that she had that she came to the conclusion that was going to lead to harm of her students. After coming to that conclusion, she decided that she didn't care. So what? I'm going to leave that threat of harm to those students because of JT having a firearm. The Commonwealth hasn't met its burden to establish a willful act. The Commonwealth has not established the specific names of children and their ages that were present in that classroom. We're going to ask to consider striking the Commonwealth's case.
Thank you, sir.
Okay, there he asked, we consider striking the Commonwealth's case. And Duck Butt, oh, nope, that wasn't Duck Butt. Here it is. Duck Butt has entered. Hey, C Mastiff, thank you. Look, this is our fake Lola for now, and then we have meat, and then we have the duck butt because we around here doing the butt, doing the butt. All right, you just got done at the grocery store. Okay, yeah, Judge asked, yeah, Purple Lips ate. So in case anybody's wondering, I put on my beautiful bright pink because this is the only wild shade I have of lipstick. To encourage the judge with her beautiful purple passion lipstick she has today. It was a very bold choice. And yeah, and the defense attorney just asked for the case to be dismissed. So thank you for being in the duck pond, everybody, where we let shit roll off our back and we just sit around here and enjoy the review. So let's see what the prosecutor has to say about this. And then we're going to go watch the little review.
All right, just a moment.
Just a minute, please.
Your Honor, I'll try to address defense counsel's arguments in order. The first was that he did not specify children having been in the classroom, or prove that children were in the classroom. What the Commonwealth is required to prove is actually what is in the indictment. And what's in the indictment is being a person responsible for the care of students under the age of 18 at Rich Neck Elementary School. So there's no need for us to prove that they were in the classroom necessarily, though certainly victims, we would argue, are in the classroom, but only at the school. That we did not present specific names is not required. The requirement of the statute is that a person responsible for the care.
I have a little, let me just because, pause for commentary. We didn't say the children's names. We gave initials, y'all. That was part of the deal. Where is he going? That was, that comment was irrelevant to me.
Of the child under 18, willful act of omission was so gross, wanton, and culpable as to disregard human life. The statute defining what must be included in an indictment does not include a victim's name. And we can think of common examples of indictments that sometimes don't. For instance, did assault and batter another is a very common indictment that does not include any victim's name. So the jury would, the way it is indicted now, be free to find up to the number of victims that they believe existed, in this case with a maximum of 8. And certainly no indictment can be returned twice to the same victim, and that can be explained to them. But at the end of the day, the jury is the fact finder, and they can decide whether what number of victims there were, if any. And so we think it is inappropriate to try to narrow that to specific names, but rather that the jury can decide based upon the evidence that they have, how many to return or to return none. I'm sorry, how many to find guilty on or to find not guilty on all. Given that the argument generally being we didn't prove there were victims, I think that's definitely false. Specific children were referred to, 5 of them by my count, RR, SD, GG, MG, and KS were the specific children that we referred to during the course of the trial.
Ms. Jenkins, if you go with the initials one more time, I have SD, GG, MG,
KS, and RR.
Thank you.
So we have a total of 5 children that we identified with specificity. But I'll point to the testimony of Ms. Zwerner, who said there were about 20 students in her classroom, many of whom were in her field of vision at the moment that she was shot. And I would propose that it is up to the jury whether they believe more or fewer victims exist of this crime. And so we believe we should not be required to name specific victims in either the instructions or the indictments. The argument that we did not prove age begins with a reminder of two things, and of course the court is aware. The burden of proof at this stage is the light most favorable to the Commonwealth, but I think more importantly, that circumstantial evidence is evidence. Had testimony from several parents who said that they dropped their first grader off at school, that their child was in first grade, and that they were in Ms. Zwerner's class. Ms. Zwerner testified that first graders are about 6 years old. And throughout this trial, we've instructed witnesses on the record to refer to people under the age of 18 using initials, and you had several parents come in and testify using only the initials of their own children. The overwhelming evidence then is that these children were under the age of 18. No, we don't have all of their specific ages, but they were first graders in Ms. Zwerner's class, and they were students attending an elementary school. And so I think that the proof of age has been sufficient to survive the motion to strike. There were two legal standards mentioned by defense counsel in his argument to the court. And one was that he indicated that we had failed to prove that the defendant knew of the danger. But if you consult the model jury instructions, that is not the standard. The model jury instruction for criminal negligence tells us that to constitute criminal negligence, the Commonwealth must show that the defendant either knew or should have known that the probable result of his or her acts or omissions would be serious injury or death to a child.
I have a question. Do you think, and this is just asking a total off-the-wall question, do you actually think when she got hired for that position, she ever in her wildest fucking ducking dreams thought she would be in this position right now? Do you actually think my mind is just going 90 miles an hour with that thought of you take this job position as an assistant principal, and never in your life would you think, oh, I'm going to be on trial, for a teacher being shot. Never. This is totally off the wall. I mean, just as a lay person, just thinking that, this could happen to me because I'm out here doing my job. Yeah, and yet she is. So, right.
Given that, the correct standard for the court to apply is not that Dr. Parker knew there was a danger necessarily, but that she should have known of the danger. Having said that, she did know. There were multiple warnings she received from multiple people that there was an armed student. And as I argued during the trial on several objections, whether they thought it was a toy, whether they thought it was a knife, whether they thought just the mere fact that a possible weapon is on campus should have triggered the response defined in the crisis management plan, yet it did not. So it should have known and not known. The second legal standard defense counsel left out is from the willful act definition jury instruction. And so the model on that says a willful act is done with bad purpose. That's what defense counsel pointed out, but it's with bad purpose or without justifiable excuse. And I would argue that that is the part that we rely on here. I do not argue that Dr. Parker had a bad purpose. I will concede that fact. But the law says it's either of those, a bad purpose or without justifiable excuse. And I certainly do believe the evidence has shown that she willfully omitted acts that she should have done, and that she had no justifiable excuse for that willful omission. Given that, Judge, I ask you to deny the motions to strike.
Thank you, sir. This is the defense motion, so they can have the last word. Anything additional?
Just want the court to keep in the forefront, again, the actions of everybody. Nobody acted as if there was a actual trial. Not following school policy doesn't result in criminal.
Yeah, I'm kind of with him at the actions of everybody. It's the actions of everybody. You know, how do I say this? As an adult, you'd think that you'd have a responsibility if you hear all this stuff. I don't know. My thoughts are all over the place with this. Let me just let them talk.
Allegation. There were acts that should have been done, definitely in hindsight. But based upon information that Dr. Parker had, she did not willfully take any action, or there was no willful omission on her part to put these children in harm. Again, mistakes occurred, but there was definitely no criminal intent. And I would submit that her actions in
I have to agree with him there.
At the most, it was a lapse of judgment.
Yep.
Somebody makes
Him saying that it was no criminal intent and most of it was a lapse in judgment. Right there, that like rang a bell for him. Oh God, shoulder, ding, 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 ding. I'm having shoulder pain. I've been having it for a couple days, and then I fell and bumped into the wall last night, tripped with the same shoulder. So
mistake that should not result in felony allegations or definitely felony convictions. So omitting a step in a school policy should not be considered to be a crime. She acted on the information that she had. She took the steps that she thought were necessary. She did not believe that there was a gun. Nobody that was there acted as if they believed that there was a gun. And I'd ask that
you're right, Cindy.
the Commonwealth, even at this stage, in Black newspaper, the Commonwealth has not established a willful act of omission. Definitely, the Commonwealth doesn't succeed. That there has been no specific proof of the age of any child that was in incarcerated.
Sorry about that. No, I was going to say, Cindy, you're right, because if anybody's going to be held accountable, it should be her because of her position. But the mistakes of everybody else, that's where my mind keeps going is there was so many other people involved, all these other teachers. And I'm just, the steps just seem, I don't know. I've just kind of been all over the place with this trial. Like I said, we went into this kind of blind with a little bit of knowledge. And where's my Hannah Banana, my little LWAP baby? Yeah, Hannah's gonna be called. She gonna be texting me later. What the fuck, Rubber? What the fuck? What the fuck?
And further before the court makes a rule on the motion to strike.
No, you're right.
I will be honest, we could have done that yesterday. I expected more substantial motion with case law and additional principles of law that the court would probably need to read.
She said we could have done that yesterday. Look, she's like, y'all, we didn't have to be here today, damn it.
Doesn't consider, but we are where we are. Having considered this case for 4 days and listened to the motions of counsel, and the division of labor in a criminal jury trial. So in that division of labor, in those legal proceedings, questions of facts go to the jury, questions of law go to the judge. A question of fact asks what happened, and it requires evaluating evidence, such as the witness testimony and or physical proof. Questions of law ask how does the law apply to those facts, and requires interpretation of statutes, precedents, and constitutional rules. And that's kind of legalese with breaking it down. The judge decides the question of law, which is what law applies, procedure, and runs the courtroom. In this case, a criminal jury. The jury would decide the facts, which is what happened. To give an analogy, because this case doesn't put itself well to analogy. So,
Y'all, I'm total side railing here. This is a crocheted collar with the purple in it to match that beautiful lipstick. You go, Judge. You go with your lipstick. But I just need, y'all, I had to do my Zoom for a minute because I needed to see. I thought this was crocheted and I got to be really nosy. It is.
somebody is given a ticket for speeding, 70 and a 65, but they're stopped in the parking lot. The jury decides the question of fact.
Now I can't get a magnifier off. I can't get the magnifier off. I know it does. It looks elegant. I can crochet, but I don't know about all that. Y'all, I can't get the magnifier turned off. I don't know how to do it. Hold up. Hold up. Okay, there it went off. Sorry. I'm playing in the background here. It does. It looks so elegant. See, I said it's so pretty. Y'all.
70. The judge will decide, does the speeding law apply in the parking lot? So that's the way to wrap your mind around the difference between question of law and fact, which can get quite convoluted. With the question of fact being resolved by the trier of fact, which in this case is the jury, and their job would be to weigh the strength of the evidence and the credibility of the witness. And judges resolve the questions of law. And what would be put to the jury in this case was whether or not Ebony Parker is guilty. And that would be the question of fact. I do all this, say all this because the distinction between law and fact can become convoluted and they can be mixed. It can be a mixed question of law and fact. The Supreme Court itself has acknowledged that it can be an imperfect science of where is that dividing line. But identifying that line is important, critically important, whether or not it's a question of law or fact. Question of fact goes to the jury, they make the decisions. Question of law, it stays with the judge. And I guess for purposes of the parties' understanding, that influences the courtroom decision maker, the appellate review, how evidentiary rules are administered, and the application of precedent, which I would say there is no precedent for what's before the court of an administrator being criminally charged and tried for what has been presented and what happened that day, January 6, 2023, at Richneck Elementary School in Newport News. This court is finding that it is presented with a question of law, which requires resolution by the decision maker. The decision maker on questions of law are the judge, and whose decision is that, and my decision is that this is a matter for the court, and the court is of the legal opinion that this is not a crime, not under the common law of Virginia, nor under the code of Virginia. And the court is going to explain its rationale and ruling. With that being said, if it's not a crime under the common law, nor under the code of Virginia, should the legislature wish to make it a crime, then they will create specific statutory language to do so. When reviewing the statutory language, the court is bound by the plain meaning of that language and must give effect to the legislature's intention as expressed by the language used. And unless a literal
Look at her. She's crying. She knows what's happening. She is crying. Hey, Denise. Look, Denise, look, here, real quick. You know what? We're going to make me big real quick. Look, I put on bright pink because that's the closest color I got, okay?
interpretation of the language will result in manifest absurdity. So now I look at the statute. Virginia Code 18.2, 371.1. What the indictment charges here is under paragraph B of that statute. It reads, any parent, guardian, or other person responsible for the care of a child under the age of 18 whose willful act or omission in the care of such child was so gross, wanton, and culpable as to show reckless disregard for human life is guilty of a Class 6 felony. The indictments in this case don't address specific individuals, but they list students. The court finds that what has been presented to it is a mashup of legal theory. And it is not clear, based upon the plain meaning of the statute, that these facts are crimes. In the court's analysis, the court is asking, is the crime that Ebony Parker didn't follow Newport's policy and procedure, of which was put into evidence, which would have required two people to search the person of JT, either two administrators or one administrator and one security officer, of which the security officer was on site at a different school performing their duties, and the principal, the other administrator present, that's known in this proceeding, was in scheduled meetings during testing. Is the crime that Dr. Parker didn't direct a search of the child's person after being informed that the book bag was clear? Are the 8 counts of the indictment based upon the number of children in the room when the firearm went off? Are the 8 counts of the indictment based upon unfired bullets remaining in the firearm, which would be contrary to established case law as they have to be discharged? Is the delayed reunification reckless disregard for human life? Is it the emotional trauma of the exposed child who was in the classroom? I believe the initials were KS. Is that the reckless disregard for human life? Is it the fearfulness, bedwetting, and hypervigilance of all the children in the school that day that comprises the reckless disregard for human life? Is it because JT wasn't expelled prior to January 6, 2023 due to his previous behaviors, which presumably would be in the province of the prior principals, Dr. Goodman and then Ms. Foster? Or is the crime the lack of heightened response from Ebony Parker due to her awareness of prior issues with JT? The court is unclear. And as previously stated, those legal theories do not fit the plain meaning of the statute. If they are to amount to a crime, then the legislature will need to codify it. Therefore, I do grant defense motion to strike in whole on all 8 counts of felony child abuse and endangerment under indictment CR, the indictment number 24999-541-01-08. So those matters are dismissed. I want to add, my ruling today is based upon legal principles only. It is inappropriate for me to give my personal thoughts or express sympathy or concern, but it's understanding what happened that day was awful, that is agreed upon by all. The criminal matter before me does not call for me to discuss the Newport News school system or make political observations, and I will not comment on optics or engage in speculation. For the media who has contacted this court constantly over the past 2 weeks, there will be no further comment from this court, except to commend the attorneys on both sides, Mr. Jenkins, Mr. Rogers, and Mr. T, for zealously advocating their respective positions and treating this forum with the utmost decorum. It is 9:46, and I did not have the jurors reporting until 10. So I'll ask the parties how they wish for me to discharge the jurors, if they want me to just tell them when they report to the room, or have them brought out and do it on the record. But in discharging them, I will remind them that no one from this court will contact them and direct them about this case. And I will ask the attorneys to please inform all of the witnesses that were to remain constructively sequestered that they are released. So from the attorneys, how would you like me to inform the jurors who are still coming in the building that they're discharged from the duties for this case?
Your Honor, I feel like we should discharge them on the record, but I would have no objection at all if the defendant or other parties wanted to leave and just do that with counsel.
Just counsel only.
That would be fine.
Okay, defense position.
Yeah, I'm actually okay with the Commonwealth position.
Okay, so I will step off the bench. So we'll be in recess, and then we'll discharge the jurors on the record once they all report. And to parties, please be quiet. And however you feel about the court's ruling, you can express that outside of the courtroom. This is still a professional legal forum. All right. Thank you very much. The sheriff, come get me when they're all reported. Thank you.
Please rise.
Thank you.
Court stands in recess.
Whew. Well, I don't know about y'all, but that was a little emotional for me. Because again, I keep thinking of if it was me and I had a job, I would be completely shocked that my job entitled this. I'm gonna play a few videos. This one is she was leaving the court, and I have a few videos put together of afterwards. There's a couple of the lawyer speaks and stuff. So we're gonna listen to a few of those. This is very this was a little emotion. It was a kind of emotional for me. My thoughts are all over the place, and I'm sorry for being a little scattered right now. But yeah, this has been
In
interesting.
this afternoon following this trial. Let's check in now with Brianna Fallon as we break down how people are responding. Brianna.
Yeah, Ashley, it was a very
Oh, wait, here. Oh, fuck, my arm. Real quick, I'm gonna show y'all a response just because I respect the hell out of him, and we're gonna move me. I'm gonna put me behind, and we're gonna do the zoom feature. Watch his face.
Law of Virginia, nor under the code of Virginia.
It's not a
And the
crime.
court is going to explain its rationale and ruling.
Watch.
With that being said, if it's not a crime under the common law, nor under
I love
the code of
Recovery
Virginia,
Addict.
Just dismiss
should
it.
the legislature wish to make it a crime, then they will create specific statutory language to do so.
He gets so
When reviewing the
excited.
statutory language, the court is bound by the plain meaning of that language and must give effect to the legislature's intention as expressed by the language used. And unless a literal interpretation of the language will result in manifest absurdity. So now I look at the statute.
So you see other people are out here watching the same thing. Here is this is a psychologist. This is Dr. Patrice Berry.
Of felony child harm. And the judge pretty much said that it was unclear based on the law that what was charged, that it really didn't fit the current laws. And if we were going to hold administrators responsible for something like this, that there needed to be updates by the legislature. So this case was dismissed. This was right after the state rested on Wednesday, May 20th, and today, this morning, Thursday, May 21st. Now, there will likely still be civil issues. So I believe the
Mhm.
families will be suing Dr. Parker and anybody else they can.
Yes, keep in mind, we do still have that civil suit out there with Dr. Parker and these parents. I looked for it, I couldn't find it. I didn't wanna bother Hio today, but I'm gonna do some more research to see if I can find more info on that civil lawsuit between these parents and Dr. Parker. But that's gonna be an interesting thing to kind of follow in the background to see what happens with that civil lawsuit.
Can civilly, and civil court is, so the burden there is, I think, preponderance of the evidence, something like that, and criminal court is beyond a reasonable doubt. Even though things aren't happening with the criminal case, so that has been completely dismissed. All those counts have been dismissed. We will continue to follow what happens with the civil trials. Some of those may settle. Who knows? If y'all have general questions, let me know.
Yeah, some of them may settle, so I don't know, that I didn't hear her say. Hang on, let me look real quick. With prejudice. With prejudice. 8 felony child neglect charges against Ebony Parker cannot be brought to trial, filed by prosecutors again. So there's your answer. There's your answer, Southern. Okay, let's go back over here and finish watching her.
Very emotional morning in that courtroom.
Can't bring
The
charges
moment
again.
The judge decided to strike down all 8 felony counts. You just heard sobs from Parker because of all the emotion. She told me outside of the courtroom that she was just feeling pure relief and she's ready to move on with her life. But I do want you to take a look on your screen. We did follow Parker outside of the courtroom. You can see her leaving the courthouse this morning. While she did not speak much about the case on camera, again, Parker and I briefly spoke outside of the courtroom, and she tells me she is feeling pure relief and ready to move on with her life. Defense attorneys say they are also relieved, calling this a landmark case where all 8 felony child neglect charges are completely struck by the judge. Here's reaction from defense and prosecutors as they left court this morning. And what was your just initial reaction, once you realized what direction the judge was going in?
Relief, happiness.
What's next in this? Is there anything or?
There's nothing from me. I don't have anything else to say about it.
Gotcha. And while Abby Zwerner was not in court this morning, we do have some reaction from her attorneys in a statement, which they said in part, a Newport News jury has already spoken, returning a $10 million verdict in Abby's favor. Yet, even today, the city of Newport News continues to resist accepting responsibility and delivering the justice that the verdict represents. Live in Newport News, Brianna Fallon, 13 News Now.
Okay, so I copied and pasted it, which didn't work out well for me. When I looked it up, this is what, in depth it told me. Where did I put it? I had it right here. So it says that she defended Journey, because I seen Journey popped in late. To strike the case, the judge ruled the prosecution arguments relied on legal theories rather than a solid codified law. She concluded that Parker's administrative inactions did not constitute a criminal offense under the Code of Virginia. She also noted that the issue of holding school administrators criminally liable for a school shooting was too novel and would need to be formally legislated by the Virginia General Assembly. And
once again, Madison, good to see you again. Welcome back. And before we get to Ed Booth, any more updates that we need to know?
Yeah, no exact updates. I mean, you've heard that we've gotten sound from both the prosecution and the defense in this case. Again, we've got the backdrop of the Newport News courthouse behind us. Connor, last time we spoke, you had questions about some of the statements that Abby Zwerner's lawyer passed along, as well as also some concerns about why the judge kind of made the decision that she made here in the case. And luckily, to help give us a little bit more insight to that, we've got legal analyst Ed Booth with us right now. And Ed, thank you so much for making yourself available for us and coming out, joining us here in the field to talk about this case. I mean, in hearing that the judge has dismissed these 8 counts, knowing that you've been following this case for 3 years, what was the first thing that went through your head on a legal basis?
Well, as any lawyer would think, the judge has taken the case away from the jury, which happens both in criminal and civil cases. But as soon as you hear that ruling as a lawyer, you understand that the judge has considered the facts in the law as put on by the Commonwealth and decided that the jury doesn't need to hear the case because those facts and that law, or the combination of the two, don't equate to something that should go to a jury. In other words, the judge is going to say, I'm going to take this away and make a ruling, essentially direct a verdict in favor of the defense because certain elements or certain aspects of the case wouldn't merit allowing it to go to a jury.
Right. And I think over the last couple of days, we've also seen some confusion from the jurors as well. We remember on day 2 or day 3 of the trial, we were hearing for a possible mistrial because of the jurors possibly asking questions about what was actually put on the record. When you hear that there were so many stops and starts in this case because of hearsay, because of what the statutes were actually allowing for the defense or the prosecution to bring to the table for the witnesses, what comes to your mind when you hear that the jury was kind of already questioning the information that was put on the table when they didn't even see all the evidence yet?
Well, sure. I mean, as a trial lawyer, when you're putting a case on in front of a jury, I mean, things don't always go exactly the way that you hope. That's just not the reality of trials. But, you know, a smooth progression of the evidence and something that makes sense and is easy for the jurors to follow is the ideal, right? That's what we want. And when you get something less than that, the more confusing it becomes for them, the harder it is for them to process the evidence. But
So, are we trying to say that it was too confusing for the jury? There was not enough evidence for the what is he this seems like all of it. I just squirreled. I'm sorry, I squirreled just for a second. I'm not sure what happened.
ultimately, they didn't have to make any decisions because the judge essentially made the decision for them and granting the motion to strike that the defense made.
Well, I think we may have seen a little bit of an inkling of that yesterday when that motion for a mistrial came up, because obviously that was presented by the defense, but it was the prosecution who said, I actually think I agree with that. And that's what caused the judge to go into recess for a bit. So knowing that there were kind of agreements in the confusion or the instances that were laid on the table from both attorneys, both sides here, is that kind of common in a case like this, especially when we've got a case that's so contentious as the one that is here?
It's not super common. I mean, sometimes one side wants a mistrial, the other side is opposed. Occasionally, you have something where, both sides are kind of like, okay, we got a problem. I mean, that can happen in both civil and in criminal cases. Is it real common? No. I mean, generally speaking, one side saying, please give us a mistrial. The other side saying, no, you don't need to do that. Whatever happened, because happened for a lot of reasons, right? Whatever happened isn't bad enough or serious enough or doesn't warrant granting a mistrial, and that the trial should continue. Now, I wasn't there yesterday, but my understanding from what you just told me is that the Commonwealth is saying, well, okay, that could be an issue. So, clearly there was at least some common ground in terms of what had happened during the conduct and course of the trial that at least gave both sides a little bit of concern. But it sounds like ultimately that wasn't granted, and the judge went on to grant a motion to strike, which is a different motion entirely, and an important one typically made in criminal trials.
Well, that was good. Going to be my next question for you. I just want to get kind of some clarification for the people at home on what this truly means. This decision doesn't mean Ebony Parker is guilty or innocent here. It kind of just means that the judge has found that there's not enough for this case to kind of stand on, correct?
Well, yeah, it's called a motion to strike the evidence, but basically it's a motion to dismiss the case because the prosecution hasn't met whatever the elements of a particular crime are. So, I mean, think of it we call it a motion to strike, but in essence, it's a motion to dismiss. So, that kind of motion is always made by the defense to say, Judge, we don't need to go any further. We don't need to put on any evidence. We don't need to have a jury consider anything because the elements of the case aren't here. I mean, I'll give you a perfect example. I mean, if somebody was charged with arson, but the Commonwealth failed to prove that the fire occurred by arsonist means, in other words, was intentionally set, that's a core element of the crime. And if you fail to prove that, well, that case shouldn't go on to a jury and a defense shouldn't have to put on any evidence. So it can happen for a lot of reasons, but it's very important because jeopardy has attached, witnesses have been sworn. So, this is the end of the case, but it's the end of the case because the judge has said that there was something that wasn't met in terms of the prosecution's proof.
Do you think that this might open the door for another case? Is that something that could happen here? Or do you think that since this has kind of been the decision, this issue won't be brought up again in the courts? Could the Commonwealth bring it up again?
Well, it's double jeopardy applies. I mean, when you swear witnesses and begin the trial, that is a trial. And people aren't tried twice for the same crime or set of facts and circumstances. So, no, I think this is
the end. It's the end of that. So let's go over here. This is the lawyer when he was coming out of the courthouse, and they got to talk to him for just a second for Ebony Parker.
Correct outcome was reached, and we're thrilled for Dr. Parker. Thank you.
What was that moment like when the judge said this didn't constitute a crime, and then Dr. Parker started sobbing?
Right. Yeah. It was just a relief for her, great relief for her, and we're just happy that we were part of her journey.
What's next for her?
I'm not sure, but thank you so much, everyone.
Yeah, and what was your just initial reaction, once you realized what direction the judge was going in?
Relief, happiness.
How often do you see a motion to strike succeed?
Well, I've never been in a part of a case as big as this one, but very often in misdemeanor cases, motions to strike succeed. In misdemeanor cases.
This wasn't a misdemeanor case.
Right. So,
Okay.
but in felony cases, I think it's way less often. Yeah. Way less common.
Have you ever seen it before?
No, not on a felony. No. Yeah.
And this was 8 counts, right? I mean, that's pretty significant. Can you talk a little bit about that and kind of coming to that conclusion to put that defense together to get the judge to strike this?
Adams County Sheriff kicked down my door. Then I heard the glass spray. They found no kidnapping victims, just some lemon pound cake. Mama's lemon pound cake.
Attorney on this matter. I came in to assist him. I'm happy.
Sorry, what happened?
That I was able to help him, but this is his case, and he prepared diligently, and we're proud. I'm proud of him, and I'm happy for Dr. Parker.
Judge Robinson said she had no precedent to work with. Is this a landmark case and a landmark ruling?
I believe it will be. Yes. Yeah. Thank you all. We believe that the correct outcome was reached.
Oh my goodness, y'all. I'm sorry. Let's see. Let's watch this one. I'm not sure what happened. This one, no, that's not the one I want. We watched Recovery Addict and we watched her. Okay, oops. Wrong button, Sheila. There we go. Sorry, wrong button. I got too button happy over here.
Again with 13 News legal analyst Ed Booth for more.
Yeah, we figured we'd bring in the experts to kind of flesh out the judge's decision here today. But Ed, you and I have spoken earlier today, and we've kind of delved into the details here. But the judge.
Okay, this is the lady. She already talked to him, so I don't want to hear her talk again. So that's about it for this trial until we can find more on the civil case. So I know we've only been here an hour, but y'all hold on to your britches because I got more, but I got to go run an errand and I'm going to come back. So y'all make sure your notifications are on. Make sure you hit that thumbs up before y'all go out, because I need those thumbs up because I hear that helps you get the algorithm something. I don't know. I say I'm still new at this a year and a half later. But anyways, I'm going to come back, and I think I'm coming back with some Mackenzie Shirilla stuff. There's been that Crash thing that came out on Netflix, I think it was an awesome video. and there is some updates to that. There's supposedly some stuff that was left out. Dom's sister has a podcast, and I'm gonna introduce y'all to that. She Dominic and Davion's sister talk. It is crazy. It's crazy. So I want to go over that in a little bit. I'm going to set that. I'm going to try to set that for 8:30. So that'll be central. So that will be 3 hours from now. That'll give me time to go do my errands and do my stuff that I need to do. And we're going to come back at 8:30 and we'll talk Mackenzie Shirilla. So y'all always got to know, hold up, I have to do my you are special.
You is smart. You is kind. You is important.
And always remember, you are special. So until we get back at 8:30, I will see y'all in a little bit. Peace. Rubber out. Bye.